is system specific. Here, one's obligation to obey laws is not represented as a moral one at all. Rather, it is thought to be based on some features of the political system itself. Thus, someone might allege that in a democratic state, the norms of democracy require that one accept democratically established law as binding law and be willing to comply with it so long as it remains in force. The problem with taking a very general moral reasons approach to political obligation, where we consider only moral reasons that would bind all people at all times and places to obey all the laws in the country, is not just that it would all times not work, a point I have already made, but also that it deflects attention from the notion of any sort of special obligation to laws as laws. It seems we should determine what it is about laws simply insofar as they are laws and about the specific political system in which they occur that might initially engender and justify such a duty. If we cannot do this, one might wonder if we are really taking about the political obligation at all. We should then, if we want to take seriously the issue of an obligation towards laws as such, make system specific reasons our first line of attack in determining the grounds of one's obligation to obey the law. Let me summarize the main themes now of our suggested new approach to assessing political obligation. First, we should emphasize the case of people who are born in a given country and are lifelong residents there, and we should not assume that any duty to obey laws, should there be one, is a duty voluntarily taken on or in one involved in a transaction of some sort. Second, we would do well, at least some as an initial step, to focus on specific features of the political system of the country in which these people reside, to see if these features give rise to any sort of duty to obey the laws there. And finally, we should give up the quest of generality of trying to find general reasons that would underwrite an obligation of all people at all times and places to obey all the laws in their country. To follow out the new approach just suggested does not preclude us from asking moral questions. We can still ask whether a given system of political conception and institution in which the elements of political obligation have been established as embedded can be morally approved. Or we can ask whether most laws generated by such a system can be morally approved. This is the same as asking whether a system specific political obligation can be morally justified. But the question we are asking here can only be asked and answered in the order I have given. Without first showing that an obligation is owed to the laws, qua laws, and that such obligation can be a given a system specific justification. Any program for a moral justification of a political obligation would seem to be off target. It could not tell us whether or why we have a duty to comply with laws simply insofar as they were laws, and this would be to miss the point of raising the issue political obligation in the first place, or so I would argue. What would be we looking for in carrying through this analysis are reasons specific to a given political system that could bind people to conform with the laws simply as laws in such a system. If such a system actually exists to an appreciable degree in the country in which a group of people live, then we have found reasons that will bind such people to the laws there merely in so far as these are duty enacted laws, or will bind them with respect to an important subset of these laws. In following out the lines of new approach, we might be able to come up with the definition and workable notions of political obligation. We will not have time in the present study to carry through this analysis. What is important to see here is the basic approach we would be taking to it, but the analysis itself is something we must say for another day. Notes 1. For that part of the Crito which contains the Socratic arguments against disobedience to law, see Plato, 5 Dialogues, tr.g.ma, Group, Indianapolis, IN, Hackett, 1981, pp. 52 to 6. Second, for the main points, body politic, constitutional consensus, avoidance of state of nature, C. J. Locke, Two Treatises of Government, first publishes 1690 edition, P. Leslate, second edition, Cambridge University Press, 1970. Second treatise, S 97, and also SS 89, 95 to 6, 98 to 9. Locke's account of the powers of government is found in the second treatise, chapter 11 and 12. Locke's discussion of express consent, that is, the permanent or standing consent of citizen members, occurs in second treatise, SS 116-18, and his further account of it and contrast with tacit consent, that is, the temporary consent of visitors, etc., is found in second treatise, SS 119-22. Third, I said that in Hobbes' view, each subject has consented here permanently but conditionally. The condition is that government, the sovereign, does not invade the subject's unmistakably vital interest. The vital interest Hobbes had in mind are the subject's avoidance of death, wounds, and imprisonment at the hands of the government. For elaboration, see T. Hobbes, Leviathan, edition R. Tuck, Cambridge University Press, 1996, chapter 14. Fourth, the idea I have just suggested that there might be a good reason for people to act as if they had explicitly consented, if sometimes called hypothetical consent. J. Rawls is often taken to have advocated such an approach in his A Theory of Justice, Cambridge, M.A., Harvard University Press, 1999. Chapter 3. Rawls' book was initially published in 1971. Here Rawls was discussing what would count as a reasonable agreement for people to make concerning the principles of justice that should govern the basic structure of their own society during their entire lives. See also J. Rawls, Political Liberalism, New York, Columbia University Press, 1996, page 273 to 4. For an important criticism of Rawls' contract theory of justice, and for the whole hypothetical consent approach, see Ronald Dworkin, Justice and Rights, originally published in 1973, reprinted in Dworkin's Taking Rights Seriously, Cambridge, M.A., Harvard University Press, 1978, see Espionage, pp. 150-8. There continue to be sophisticated defenses of hypothetical consent as conveying the best insight into traditional consent theory. Among those I particularly recommended are Thomas Lewis on using the concept of hypothetical consent, Canadian Journal of Political Science, 22, 1989, and Cynthia Stark, Hypothetical Consent and Justification, Journal of Philosophy, 1907 2000. Fifth, John Simmons, in his book Moral Principles and Political Obligation, Princeton NJ, Princeton University Press, 1979, discusses a number of such grounds: fidelity or consent, chapter 3 and 4; fair play, chapter 5; Rawls' natural duty of justice, chapter 6; and gratitude or repayment, chapter 7. See also page 15 to 16, 54 to 5. Simmons reaches the conclusion I have identified in chapter 8 of his book. Many anarchist theorists would, of course, echo this conclusion. The idea that a theory of political obligation must concern itself in particular with the obligation of people to obey the laws in their own country is one that Simmons has brought to the fore and emphasized. See Simmons' Moral Principles and Political Obligation, ESP. Page 31 to 5, and also 37, 43, 54, 64, 155 to 6. John Horton, in his book Political Obligation, Atlantic Highlands, NJ Humanities Press International, 1992, surveys these same grounds in chapters 2 on consent and 4 fair play and gratitude, and finds all of them wanting. His suggestion that we take a different basic approach is developed in the final chapter of his book, chapter 6. For a similar line of attack with a similar conclusion, see Ronald Dworkin, Law's Empire, Cambridge MA, Harvard University Press, 1986, Chapter 6. 7. The approach I have just outlined in this paragraph has been taken by several theorists. See, for example, Rawls, A Theory of Justice, S19 and Chapter 6, ESP. SS 51 to 3. R. Martin, A System of Rights, Oxford Clarendon Press, 1993, Chapter 8. Also, J. Waldron, Special Dies and Natural Duties, Philosophy and Public Affairs, 2022, 1993, and the chapters in the Horton and in Dworkin cited in Note 6. For criticism of this approach, see Richard Dagger, Membership Fair Play and Political Obligation, Political Studies, 48, 2000.
My name is Vishnu Priya, and I am going to start reading Political Obligation and Political Concept. Firstly, I am starting with introduction. Political obligation is a broad notion and covers many things. Some have said, for example, that the citizen has an obligation or duty to vote. Others have claimed that citizens may have a duty to serve their country and possibly even to fight in its defense. Most people who talk of political obligation, however, have one thing in particular in mind: the citizen's duty to obey the law in their own country. The issue I want to discuss in this chapter is whether people do in fact what good and justifiable reason for complying with laws that go beyond mere fear of punishment, and if so, whether they are bound or obligated by those reasons to comply. First topic: one main argument for a duty to obey the law, consent. Socrates had to decide whether to disobey an unjust but legal decision. The remarkable thing is that he decided to obey for what he thought were sound reason in circumstances that would cost him his life. Socrates believed people had a moral duty to obey the law. It is very strict duty based on an agreement they have made. What is distinctive about the agreement or argument? Socrates ascendant. Two is that it puts the issue in terms of justice or morality. In our own political tradition, there is an argument somewhat like the Socratic one. It stresses not the morality of keeping agreement, but rather the connection between a legitimate constituted government on the other hand and a citizen duty to obey the valid laws issued by such a government. On the other hand, the obligation is a strict one. It attaches to all law and can be overridden, if at all, only in exceptional cases. In this theory, usually associated with Hobbes and Locke, in particular, a contract is said to authorize a government to make law and to bind subject to strict obedience. Actually, the theory of Hobbes and Locke are not quite so simple as this. Locke argues that at a certain point, that is, upon reaching the age of adulthood and then by staying on more or less voluntarily in the face of unexercised right of immigration, people become member or part of a particular body politic. The main functions of any such body is to create a constitution or form of government, and presumably there is a consensus among the citizens as to where that is what institution. The main power of the government have been loaded. Indeed, Locke say if there were not this consensus, the body politics would come apart, would simply disintegrated, and could only be held together by obvious and clear improper force. Now from these two facts, that one is a member of body politic and that there is a consensually based on constitutional government for it. It follows for Locke as a matter of logic that each citizen, means each member of a political society so organized, is strictly bound to obey the law duly issued by such a constitutional government, or it follows from these two fact plus one another. If laws were not obeyed, people would in fact have returned to the unwanted state of nature that each member has the strict obligation in question. One has in short not consented in so many words to obey the law. Rather, one has consented to be a member of body politic, and from the fact plus one or two others, it follows logically that the citizen has a strict duty to obey laws duly issued. One is thus obeyed as if one had in fact expressly consented to obey. The doctrine of consent in Hobbes is perhaps simpler. Hobbes argues that all subjects of all government consent in one and the same fundamental ways. They simply stand aside from their own exercise of natural right, from the right to do anything they are physically able to do. Thus, each subject has individually consented, or in fact promised, particular but conditionally to waive the exercise in defense to the exercise of that same right, the right to do anything, by the government. Hence, the subject consent to be under the sovereign will and are obligated to comply with it, whatever it is, in all or almost all cases. For the contract theorist, just as for Socrates' idea of an argument The relationship of citizen to the government and its laws is constructed on an analogy with some non-political undertaking like promising, agreeing and consenting or signing a contract, which is obligation creating in character. It is the fact of agreement or act of consent that ground the obligation to obey the law in all this theory. I can see two main problems with the overall approach. First, there is the problem of what counts as consent. Second, there is the problem of whether consent so conceived can really bind people to obey all or almost all valid laws simply because these laws were issued in the correct way by a legitimate or effective government. What courts as constant all of all of the tourist court mayor residence permanent residence during adulthood. Hobbies adds the interesting twist that a residence could even bow one head and go on living under a concurry on pain of death.
if such consent were not given, and that would count fully as consent. Many people are reluctant to think that the mere continued residence should count, especially under the condition. Hobbes involves it as having exactly the force of an explicit and solemn promise. Some have said that voting in a free election should so count. Well, so voting might commit you to accepting the outcome of the election. We might grant, but why should it commit you to accepting being obliged to accept all the laws issued by those elected? Some of these laws might be foolish or unconstitutional or even wicked. Suppose you voted on the losing side, your candidate did not win. You voted that way because you didn't want a certain bad law passed, and now that candidate you voted against has along with others supported that very law. Or suppose it was really a wicked law like the US law in the 1850s, which required runaway slaves to be recaptured and returned to their owners, and you are a voter in the state of Massachusetts who didn't like the idea of such a law, who had voted for a candidate who opposed it. A candidate was then selected, but those who voted against this law then defeated in the candidate meeting of national legislature. This example suggests that if we goes a bit far to say that simply by voting in a general election you are committed to accepting this law and are obliged to obey this. But what about an explicit and a solemn promise, a full-bodied agreement to accept all valid laws and to be bounded by them? Would that work? Not too well. Most citizens have never consented or contracted in a way that can be regarded as really counting to obey the laws of the country in which they reside. For example, not everyone has engaged in a meaningful act of consent in Britain, America, or Canada. In fact, relatively few people there have done so. Therefore, a full body actually consent is required. The contract, therefore, cannot account for an obligation to obey the law in such countries. One could always reply, well, if everyone had freely explicitly promised to obey the law in their own country, that would surely count. We could still ask if such a promise counted as consent, whether such explicit consent would or could blind those who had taken that oath, could oblige them to obey all the valid laws of the land simply because they were the country's law. Is the strict obligation to obey the law grounded merely in the bare existence of consent to do so, or it is grounded in whatever good reasons one might have so far consent in the first place? Clearly, if we simply cited the reasons, then we no longer have actual we no longer have actual consent as the ground of obligation, contrary to what the contract theory requires. Suppose, though we cited both the fact of an explicit and widespread agreement in a given country and good reasons for making such an agreement, one could still question whether the fact of explicit consent really added anything to this reason. Consider if we regard our obligation to obey our country's law as a moral obligation, then we probably also believe that most of or very many of these laws have a good moral context. But would not the provision in such laws control our conduct, moral speaking, even if they were not set down in law? By the same token, they would also control our conduct, morally speaking, if we had never explicitly and solemnly promised to obey the laws of the land. The matter becomes more complicated when we consider that they are morally indifferent. I would think of the question of moral obligation could arise in such cases only where what the law required could be shown to be necessarily or sufficiently important to the government's continuing ability to encourage people compliance with those laws that do have a moral good context. When we come to weak laws, I think the matter changes considerably from what it was in the two earlier cases of laws with good moral content and the laws of on the case of laws with morally neutral content. I do not think it's possible to ground the moral perspective of obedience to law on a foundation of indifference with respect to whether the laws are, in most of the cases and in the long run, of a morally good or at least morally acceptable content. The morally preassumption here is surely against evil law, and this preassumption will tell against any morally based obligation to obey such laws. In the analysis we have given, a promise to obey evil laws could not be morally justified, and any such promise, even the promise to obey all laws, would not have obligingly weight. Another main argument for a duty to obey the law: benefit. Dissatisfaction with consent theory has led political theorists to consider other possible ground of an obligation to obey law. What follows is perhaps the most commonly cited alternative. It is often alleged that the receipt of benefit obliges one as based on a proper sense of gratitude to show a appropriate responsive conduct. Some have said that when the benefit comes from the government, the appropriate responsive conduct is to obey the law. Of course, some benefits are open, they come to everyone. One can hardly help but receive them. Sometimes benefits come even though one actively tries to avoid them, but some benefits are possibly sought or at least voluntarily received knowingly and willingly. This, it might be said, are the ones for which one clearly owes a duty of gratitude, and appropriate responsive conduct is owed to the benefactor. The question is though whether where these benefits are positively sought or voluntarily received from government. Does anyone owe obedience to law as one feature of one appropriate responsive conduct? Does one indeed have an obligation to obey all laws on such a basis? Consider the following example. A black student in South Africa during the period of apathetic request and receive admission to a state-run high school and some monetary aid from the local education authority. Suppose that is paid for out of tax revenue. Suppose it is believed that the student might now owe a debt of gratitude to be paid back in some sort of appropriate responsive conduct. But what conduct is appropriate? Contributing to state supported education in the future might well be, but it can hardly be alleged that one now is morally obligated to support the government obey its laws. The same could be said of a white student in a similar circumstance. That student might be thought to be obliged to contribute to state supported education in future, but there is no good reason to say that this student, who has probably received more benefits overall than the black student, is morally obligated any more than is the black student to support the government and obey all its law. Indeed, we could vary the picture somewhat to include important benefits people receive. For instance, both our students might have been benefited greatly from public health measures. Would it follow this that either is morally obligated to support the government and obey all its laws? The basic point I am making, that there is no obligation to obey all the law of the land in such cases, would probably hold if the evil apartheid laws were completely removed from the picture. The fundamental question here is whether the appropriate responsive conduct said to be owed in these two cases of education and public health can reasonably thought to include supporting in the government and obeying all its law. More to this point, if were to the run through a wide number of cases of various benefits actively sought or voluntarily received from the government, or of important benefits merely received, and reach the same conclusion in each case, then you don't think gratitude for benefits received does ground an obligation for received to obey all the law of their country. Some have pointed to a special version of benefit theory called fair play to make the case for a duty to obey law. Here is the picture they represent. People are engaged in a joint activity, a practice, or an enterprise. This is widely beneficial. The benefits of this activity can only be obtained if the people join in, but doing so carries certain cost for each of them. Now let us say that I am engaged in such a practice in which others are doing something benefit me, and I have voluntarily accepted this benefit. Now it comes my turn, and after a few years have passed, to pay taxes. Fair play theory alleges that I am obliged by my participation in this practice to do my share, to return in kind the benefits that I have received by paying my taxes, and this means complying with the tax law. Technically, the obligation I owe under fair play is to other participants in the joint activity. It can become an obligation to obey the law only indirectly, insofar as the activity itself is essential or significantly involved with one's being law abiding. This said, I cannot quarrel with the analysis just given. The question, though, is whether you or I have an obligation to obey all the laws. The same thought experiment I suggested earlier would work here as well to help answer this question. The issue we are raising here is whether the appropriate responsive conduct said to be owed in this case of receipt of benefits from tax revenues raised and spent can reasonably be thought to go behind confronting to the tax laws to include supporting the government and obeying all its laws. Surely it doesn't. And if we do take each practice up in turn one after another, we would reach the same conclusion in each case. Thus, a person who had benefited from others' people obedience to law against theft should obey those same laws where the circumstance to arise. You owe it to those others in a fair place so as to act, but there should be no generalized duty, a duty that would beyond confront to anti-theft laws to obey all the government law. Indeed, if you run through a wide number of cases involving people participation in a wide variety of practices or joint activity and lumped them all together, you might conclude that person involved should do their share to pay back in the kind benefits they have received. This may well involve a duty to obey several, even many laws, but none of this would mandate the conclusion of that fair play. The case that of benefit voluntarily received by parents in a wide variety of would ground an obligation for each of them to obey the all law of their country. Obedience to some law may not benefit everyone. The conclusion reached in our survey of fair play are of course strengthened when we consider that some laws may be evil and that such evil cannot be benefit literally everyone, and if they are any benefited in such case, there is no moral obligation, no obligation of fair play even for them to obey all the laws of the land.
A preliminary conclusion and some materials for a new start. We have now canvassed some of the main arguments for a generalized duty, a duty of everyone to obey all laws. The arguments based on consent, on gratitude for benefits, and fair play have been looked and in turn, and each has failed. Some have concluded from this that there simply is no obligation, no moral obligation, for everyone to obey all laws in their own country. In fact, there may not be standing obligation, for some at least, to obey any of the laws. Others, looking at the same sample, have concluded that none of these standard arguments will work, but these theorists have left open that another radically different approach might work, and some have been even suggested the main lines of such an approach. I tend to side with this second view, suitably qualified. The theorists we have been criticizing all treat the obligation to obey the law as primarily a moral one, and thus the grounds they emphasize are distinctively moral grounds. These theorists are interested in general grounds for obeying laws, ground operative in all or almost all societies, grounds that could cover all laws or conceivably all persons, and they disdain reasons which are local or distinctive only of a particular society or specific kind of system. But their analysis, but its very nature, creates a deep problem. They cannot show that the duty so generated by reference to this general, distinctively moral grounds, such grounds as agreements or express consent or gratitude for benefits received or fair play, can even be duties of all the people in a given country to obey all the laws there. Or so I have argued. The quest for such a generality have proven to be hopeless and unrewarding one. The second feature of this standard approach also needs bringing out. The favored grounds cited in this approach all have in common that they invoke some voluntary act on an agent's part. Typically, the agent are here said voluntarily to have concerted, or alternatively voluntarily to have received benefits, or as yet another alternative to have not knowingly participated in a participate or joint activity from which they have voluntarily received benefits of the very sort they are now being asked to provide in turn. The main point relied in all these cases is same. Having an obligation implies that one has voluntarily taken on that obligation through some sort of transaction. This pronounced emphasis on voluntariness may be of place, may be out of place. One can have duties that are not based on voluntary acts at all. For example, children, say teenagers, could have duties to their parents which are not based on voluntary transactions on the young person's part. Among the benefits they have received are many that were not voluntarily sought or voluntarily taken. For example, the enormous number of such benefits that they received when they were infants or very young children. More of the points, it may be the relationship they are in with their parents that count entirely, or for the most part, for the duties they have.
Innkeeper or employer or quite typically as member and fellow citizen in the given political society. The normative direction for conduct laid down in the law often come with the territory and are imposed simply by the rule making action of government officials. These requirements are thus unlike standard voluntary obligation in a number of important respects. They do not necessarily involve undertakings or determinate transactions that serve to bring a citizen specifically under a given requirement. They are not in many typical cases owned to definite or named individuals, but rather to all citizens. They are not imposed because the individuals has been the actual beneficiary of the very way of acting which that individual is now being normatively directed to engage in, and so on. This last point is in the deliberate contrast with the fairy play we need in short to able to discuss the duty one might have to conform to such laws without assuming that the duty is there on the basis of some voluntary undertaking or determinate transaction that has served to bring the citizen specifically under the requirement. Another dimension to this important matter of voluntariness needs mention as well. Most people are in the fact citizens or lifelong members of only one country during this entire lifetimes. They are born in that one country and they will spend their whole life there. Many others have joined them for reason of their own and have in effect cast their loads there. This we must grant, but we must be able to make a case study for to overt laws for this vast majority. those who were born there. If you're going to have any serious case of the claim that citizens have or may have duty to conform of laws, we need to ensure to be able to discuss the duty. One might have to conform to laws in the country their birth without assuming that the duty is there and can only be there on the basis of some voluntary undertaking or determinate transaction that has served to bring the citizen specifically under the duty. One final point is worth making. People often talk about a duty to conform to law which is system specific. Here, one's obligation to obey laws is not represented as a moral one at all. Rather, it is though to be based on some feature of the political system itself. Thus, someone might allege that in democratic state, the norms of democracy require that one accept democratically established law as binding law and willing to complete with it so long as it remains in force. The problem with taking a very general moral reasons approach to politically obligation where we consider only moral reasons that would bind all people at all times and places to obey all the laws in their country. It is not just that it would not work, a point I have already made, but also that it deflects attention from the notion of any point of sort of special obligation as law. It seems we should determine what it is about simply in so far that they are laws and about the specific political system in which they occur that might initially engender and justify such a duty. If we can't do this, one might wonder if we are really talking about political obligation at all. We should then, if we want to take seriously the issues of an obligation towards law as much, make a system a specific reason our first line of attack determining the grounds of one's obligation to obey the law. Let let me summarize the main theme now of our suggested new approach to assessing political obligation. First, we should emphasize the case of people who are born in a given country and are lifelong resident there. And we should not assume that any duty to obey laws should there be one is a duty voluntarily taken on or involved in a transaction of some sort. Second, we would do well, at least as an initial step, to focus on a specific feature of the political system of the country in which these people reside to see if these features give rise to any sort of duty to obey as laws there. And finally, we should give up quest for generality of trying to find general reasons that would undertake an obligation of all people at all times and places to obey all the laws in their country. To follow out the new approach just suggested doesn't preclude us from the asking perceptions and institutions in which the elements of political obligation have been established as embodied can be morally approved, or we can ask whether most laws generated by which a system can be morally approved. This is the same as asking whether a system of specific political obligation can be morally justified, but the question we are asking here can only be asked and answered in the order I have given without first showing that an obligation is owed on to the laws via laws and that such obligation can be given a system specific justification. Any program for a moral justification of political obligation would seem to be off target. It could not tell us whether or why we could have to duty to comply with laws simply so far as they were laws, and this would be to miss the point of raising the issue of political obligation for the first place. Or so I would agree. What we would be looking for in carrying through this analysis are reasons specific to a given political system that could bind people to conform with the laws simply as laws in such a system. If such system actually exists to an appreciable degree in the country in which a group of people live, then we have found reasons that will bind such people to laws there. Merely in so far as these are the duty intellected to or will bind them with respect to an important set of these laws. In following out the lines of the new approach, we might be able to come up with a definite and workable notion of the political obligation. We will not have time to present study to carry through the analysis. What is important to see here is the basic approach we would be taking to it, but the analysis itself is something we must say for another day. For the part of the Crito which contains the Socratic arguments against disobedient to law, see Plato, Five Dialogues, GMA Group, Indianapolis, India, Hackett 1981. For the main points body politic constitutional consensus, avoidance of a state of nature, see Locke to True Treatise of Government, first published 1690, second edition Cambridge University, second treatise, and also as 1890 95 to 698 9. Locke's account of the power of government is found in second treatise.
Chapter 6 Political Obligation. the problems. Alfred Russel Whitehead is said to have said that all philosophy is a series of footnotes to Plato and Aristotle. It is a good saying and would not be such a memorable falsehood if it did not contain a strong element of truth. It is a falsehood because in the tradition of Western philosophy, in the pre-Socratic philosophers deserve a mention. But just as obvious, there are more philosophical problems than were dreamt by the Plato and Aristotle in their philosophies, but perhaps not many more. And equally, the repertory of arguments pro and con, the range of responses to these problems has been enlarged well beyond the category of footnotes. But one can easily mistake the show for the substance in respect of touted philosophical advances. Another way of making Whitehead's point would be to say that Plato and Aristotle set the agenda, and this would be more true as well as more trendy, but still a falsehood. However, there is one philosophical problem which has not advanced far beyond the elaboration of Plato's arguments and the development of challenges to it: the problem of political obligation. In the Crito, Socrates is invited to collude with the plans of Crito and other friends and admirers who sympathizes with his predicament by escaping gaol and the imminent self-infliction of the sentence of death. He will be quite safe, he is assured, in Thessaly. If he accedes to Crito's scheme, the gaoler is beholden to him and informers can be bought off. Socrates will evidently be failing to fulfill the duties of a citizen of Athens. Should he or should not he take up Crito's invitation? Should he do what the city requires of him, or should he attempt to escape? Plato presents Socrates is speaking in the voice of the law and the constitution of Athens, and this voice argues convincingly in favor of his accepting the decreed punishment. The major themes of Socrates are: first, that he has consented to obey the laws, and so to flee would be to break the covenants and undertakings he freely made. Second, that he has received evident benefits from the city, that he ought to be grateful to these benefits, and that since by fleeing the city he would be doing it harm, this would be an ill return for the benefits received. These two arguments, the consent argument and the argument from received benefits, have dominated the literature ever since, though they have taken many different forms, as we shall see. First, though, we should try to become clear about the precise nature of the problem of political obligation. We do best to think of a political obligation as obligation owned by us as citizens to the state. It is tempting to elucidate this concept by first outlining the general nature of an obligation and then explaining how specifically political obligations are to be construed. Such a course would require us to distinguish obligations from duties, and perhaps duties from reasons for actions of a distinctively moral sort. The enterprise would be tricky and may be interesting, but I am reluctant to engage in it for two reasons. In the first place, I doubt whether the exercise could be successfully concluded without excessive semantic legislation. Such distinctions could not doubt be forced. The language could be cleared up by careful stipulation, which builds on distinction made in the way we generally speak. I have no ambitions in this direction, and since judgment on whether such an exercise is valuable or pointless would have to wait upon its outcome, I shall do no more here than register my doubts. In the second place, our chief interest is in the specific issue of political obligation. It may well be the case that whatever distinctions can be traced between, say, obligations and duties, taken generally, do not apply in the specific context of political obligation. In fact, I think this is the case. It makes no difference whether we speak of the political obligations incumbent on citizens, of the duties of citizens, or, to my ear, of the moral reasons citizens should recognize as governing their conduct with respect to the political institutions of the state. The last of these locutions is a mouthful, so I shall try to avoid it. The first has all the virtues and vices of familiarity. I prefer the second. My reason is informal and pragmatic. The concept of legal obligation and political obligation are closely linked, and the closeness of the linkage invites a narrowness of focus I wish to avoid. We speak of legal obligation when we wish to identify the demands legitimately made of subjects within a particular legal system. The model here is that of the generally justified coercive law, proscribing or prescribing conduct on penalty of sanctions for non-compliance. Speaking substantively, our legal obligations comprise our obligations to obey the law. There may be one big legal obligation to obey the law, or as many obligations as there are prescriptive or proscriptive laws. We are apt to think that political obligations march in step with legal obligations, and this is a natural assumption since legislation is a political process effected or authorized by the sovereign. So we are apt to think that political obligation equates to the obligation to obey the law. If so, we are in error. I think we have a political obligation wherever good moral reasons that dictate the terms of our relationship with the political institutions of the state. If there are good moral reasons why we should obey the law promulgated by the state, then we have a political obligation to obey the law. If there are good moral reasons why we should follow a call to arms made by the state, then we have a political obligation to volunteer. If there are good moral reasons why we should participate in processes which elect representative or enact laws through plebiscites, then we have a political obligation to do these things. Since I recognize that this list of standard political obligation is wider than is sanctioned by the customary association of political and legal obligation, and since I don't want to back the conceptual question canvassed above, I think it most felicitious in point of style to speak of the duties of the citizen. There is nothing odd about the thought that citizens may have duties to volunteer some service to the state or vote in elections in circumstances where such conduct is not required of them on pain of sanction. So the problem of political obligation is not on my account the narrow question of whether citizens have an obligation to obey the law. That problem can perfectly well be pursued within a wider agenda that includes other duties that may be imputed to the citizens. It may well take center stage because characteristically the duty to obey the law is a duty that is exerted against a citizen, and so one might expect arguments in favor of it to be the strongest available. But it's not the only duty that is in question, and as we shall see, the questions of whether we have such a duty may be most clearly answered in a context which brings into view other duties which citizens may recognize. That said, for the moment we shall retain the traditional focus on the duty to obey the law in order to frame more clearly other introductory questions. The first discussion concerns the ambition of the arguments that purport to establish this duty. How universal is the scope of application of the argument? Are these arguments designed to show that if any citizens should recognize such a duty, then so should all? Or may the arguments be custom-built, bespoke to the demands of citizens severely? The classical liberal dialectic can be envisaged as a series of claims made by the state against citizens who independently review the congruency of these claims. The state advances its claim by way of arguments directed to all citizens, but each modern citizen assumes the right to examine these arguments independently. We imagine the state rehearsing its arguments because no modern state can expect its claim to be vindicated solely on the basis of its pre-established authority. The state hopes that its arguments will be of universal validity, convincing everyone. But of course it may not succeed. The arguments it employs may be failures, convincing no one, or they may be partially successful, convincing some but not all of those to whom they are addressed. I shall suggest that this is likely, and so shall represent the state as advancing a series of arguments that successively widen the net over those it seeks to convince of its legitimate authority. The following outcomes are possible. A. No arguments convinces any citizen. At least one argument convinces some citizen. C. All citizens are convinced by at least one argument, but they are different arguments for different citizens. D. There is at least one argument that convinces all citizens that they have a duty to obey the law. Outcome D is the best for the state, but it may turn out that the state need not be so ambitious. If, as the dialectic proceeds, it transpires that there are no citizens who can reject every one of the arguments the state advances. Outcome C, then its objective of laying a legitimate claim to the obedience of all citizens has been achieved. Third best, from the point of view of the state, would be the acceptance by most citizens of some of the arguments it put forwards. The next question concerns the contents of the state's requirements, the second dimension to its ambitions. The state, as we have surmised, will lay claim to the obedience of all its citizens. For one reason or another, but does the state's claim on the obedience of its citizens require that they obey all of its laws? I think not. Again, this is too ambitious. First, we should recognize that the laws in place are likely to be a ramshackle collection. They are likely to be cluttered with dead wood. Alert students to the law of modern states will recognize plenty of laws in destitute relics of forms of life long gone, governing perhaps the rules of the road, according priority to horses over pedestrians or vice versa. The invocation of such rules, as in the case of Shaw versus Director of Public Prosecutions, whereby the Star Chamber offense of conspiracy to corrupt public morals was resurrected to convict poor Shaw, is widely deemed unjust. Second, some laws seem designed to be broken so long as law breaking remains within acceptable limits. I confess to having broken the licensing laws as a juvenile drinking below the age of state consent, as an adult serving drinks after closing time, and as a parent buying alcohol for my underage children. If you are not sympathetic to this example, think of your violation as a driver or willing accessory of the Road Traffic Acts. We are all of us car drivers, lawbreakers on a regular basis, so we should not be too pro-faced unless we have chosen to be politicians. About the content of the requirement to obey the law. To be effective at all, laws need to be precise in context, which defy calculations and invite contraventions. Citizens, unless they are paradoxically pernickety, know these too well, and are willing to accept, say, parking fines as a tax rather than accept the imputation of moral wrongdoing which they would generally attach to law-breaking. They invoke parameters of good luck or good judgment, where the law asserts specific constants. Are such criminals self-deceiving, or do they draw fine but valid distinctions concerning the import of the criminal law? The argumentative terrain is unfamiliar to philosophers, but certain obvious truths deserve to be recited. Unless one accepts that all illegal behavior is morally wrong, which is a question too often up for begging, one will be hard put to explain the wrongness of well-judged, unimpunged and harmless law-breaking. The most sensible conclusion to reach is the face of the philosopher who insists that we should emulate the rare but precious driver who never or hardly ever exceeds 70 mph on a motorway, is that the state requires not so much absolute literal obedience to its declared laws as a disposition to law abidingness. This whole issue is cluttered by the evident overlap of laws and moral requirements, where the dictates of law repeat and thereby endorse the requirements of morality. The scope for unshamed law-breaking will be severely constrained. Where the conduct is conventionally regulated, there must be some limit on the speed of cars, some limit on the age of the permissible drinking of alcohol. What should it be? One may expect social tolerance and personal insouciance. The most a sensible state will require, in respect of the private judgments, if not public statement by its representatives, is that citizens are disposed to take seriously its regulations, disposed within parameters of realistic laxity to obey its laws. This is not quite the view, as told me by a local policeman, that Sicilians regard the traffic laws as possibly useful advice. Finally, one should realize that laxity on the part of the state and law standards on the part of the citizens are one thing, conscientious disobedience quite another. This issue is too complex to take on board in its fine detail here, but we are required, as a final qualification to the thesis that the duties of the citizen require her to obey all of the laws, to acknowledge that normally obedient citizen may find as a matter of idiosyncratic but not thereby mistaken moral beliefs that they cannot, in good conscience, obey the law. They may judge that the proper duty of the citizen in such cases is to disobey the law. In this possibly tragic circumstances, the state must accept the possibility that well-meaning citizens may get things right or wrong without impugning the overall authority of the state. Indeed, such citizens may endorse this authority in a peculiarly